All right. Good afternoon, everyone, and welcome to another edition of Fire Law Roundup for May 23rd of 2022. And Brad is coming to us live from New York City. But Brad, why don't you take it away?
Fantastic. Well, hopefully I won't get too distracted by all the FDNY fire and EMS passing us. We'll go to Connecticut, where the firefighters' drug death leads to discipline of 8 others. And I'm glad if our viewers will watch or read the blog. We actually dealt with a very similar one a few weeks ago. This is just short, but it has an interesting twist that I would like to raise. So here, there's an off-duty death of a New Britain firefighter. And as a result of his death, I'll explain why, several officers were terminated and or suspended, demoted, and because they said that and this was pretty recent, January 26th of 22.
It was all this year. It was all this year.
Yeah, I mean, this is very current. But this firefighter apparently had a known history of drug use, but there was an investigation that led to this dismissal, the lieutenant, etc., which was just in February, for knowingly supplying, giving, selling, sharing, and using illegal drugs and prescription Adderall pills, and then lying about it. Now, my first question was, were they getting this from the station? But obviously, Adderall isn't something that any fire department or ambulance is going to carry. So this is completely, unless you have a different twist, off-duty conduct.
I think some of the transactions may have been taking place on duty. I think that was some of the, and I have no idea. I don't have any backstory to this, but I think there may have been some connection to work, but the drugs weren't being stolen from work.
No, and that one, I won't get too much into the other one to juxtapose with it. Similar, but very importantly, different facts. But here it's completely, as far as I can tell, completely off duty. And yet they're actively, they think they're helping him. But, allegedly, I guess, but they're, he then ends up dying as a result of this. And as a result of the off-duty conduct of these firefighters, they're disciplined. So I am curious, one, what the CBA says. I mean, there's a lot of information we don't have. I don't know if there will be challenges to this. But, off-duty conduct clearly is a big topic for unions to discuss. And I understand why it's important, right? You're always out there in the community, and what you do off-duty, whether it's stealing or drug use or sexual misconduct or taking a picture in Hooters in your Class A uniform, right? I mean, all real things, but they affect you. But here, it seems completely off duty. So I think that's the critical part is, if I'm a union or anybody, even a volunteer, I'm looking saying, what is my culpability for any off-duty conduct? And I'm not justifying or not justifying what was happened. My focus legally is on, my God, this was off-duty.
Yeah, and there's a complicated Garrity issue that arises because an employer can order a firefighter, a fire chief can order a firefighter to answer questions about what took place at work or that, has a direct connection to work. But the chief can't order that kind of answer. And I'm kind of stumbling over the words here, but we use the term compel. You can compel the employee to answer questions about things that are specifically, directly, and narrowly relating to the performance of their official duties. That's the
but not
official,
if you can be convicted of a crime.
Well, you can, and here's the thing: under Garrity, once you do that, it's immunized. Okay, and so if let's say we were in the same department, I'm the chief, you're one of my officers, and there was a drug transaction that took place at the station, I can order you to answer the questions, and your answer back to me becomes immunized. It can't be used against you in a criminal case. Now, the problem can be if let's say you gave you did some drug dealing in the station, but most of your drug dealing was off duty. I can't immunize. Right, as it would be. I can't immunize that off-duty, your answers to questions about off-duty activities. So therefore, if you answer those questions, and that's why you want to have a lawyer with you, but if you answer those questions about off-duty, it's not immunized, and you can be charged.
But
So,
as I understand, Garrity, you give me the warning. I don't have to answer them. Basically, my Fifth Amendment rights, right? And you can't penalize me for not answering it.
No, that's it. No. And this is why it's so complicated. That's what you just said is what I was taught in law school, and it's wrong. You would think a law professor would know this, okay? Your professor and mine probably were the same mistaken, approach. And I know you were a fire chief. You can order your firefighters to answer questions under threat of termination about a work-related matter. I use the term SDN, specifically, directly, and narrowly. They have to answer questions that are specifically, directly, and narrowly relating to the performance of their official duties. Once they do, the answers become immunized, okay? And you and I have an understanding about what is immunity. It's not really immunity in most states, okay? It's really this, basically it's going to be suppressed, okay? It's under the exclusionary rule, okay? MAP v. Ohio. But it's going to be exclusionary. But the bottom line is, you as the chief can order your subordinates to answer work-related questions, got to be SDN. But when you're engaging in behavior that involves both on-duty and off-duty, it gets very, very complicated, because if you ask them about off-duty activities, you are absolutely right. You can't use their silence against them. So it's certainly from, from the fire department's perspective, you need competent legal guidance to guide the investigation. From the union's perspective and the firefighter's perspective, you need competent legal guidance so that you duly represent the firefighter who finds himself in this situation.
Now, I've had an issue, which I love, and I know this is so far off topic, but here you have several alleged wrongdoers.
Yeah.
I had an issue many years ago. It was a great issue where all of the wrongdoers conspired, so to speak, agreed not to say anything except for one.
That's all it takes.
That's all it took. And the one, under the promise of immunity, hey, you talk to us, and the fire department says, you tell us about the other, there was 3 or so, and you're okay. It turns out he was the main actor anyway. He throws the others under the bus. They get terminated. He gets immune. They all clammed up, and it didn't work for him. So, it only takes one.
My dad, my first year of law school, my dad's law office was right around the corner from where I was living. And I used to pop in there after school and ask him, like, bounce things off. And I was asking him some questions, like stupid first year law student questions about conspiracies. And he, early in his career, he did a ton of criminal law. He was doing mafia defense kind of stuff,
And he lived to tell about it.
And he did. He kind of got, he ended that after one of his clients got bumped off. So, and
probably just found him in Lake Mead in the
but at any rate, he gave me a really good analogy, and it comes back to me. It comes back to me clearly, vividly, whenever we talk about it. He says, look, conspiracy is like a bunch of people in a canoe. And as long as everybody stays in the canoe and they're all paddling, you're going to go down, the river nice and easy. All it takes is one guy to stand up and everybody's going over.
Right.
Right. So, and whenever I think of a conspiracy, I think back to that conversation.